Yes.
And for the railways, Your Lordships, the petitioner has just made bold statements and false statements.
So,
Yes, yes, I'll show Your Lordship. We have filed a counterfeit which has not been replied. In November 2014, the date of completion was November 2014.
because that before the impugned action,
Yes.
show cause notice was issued, and how reply
Your
has
Lordship, in my humble submission, as per the Railway Board circular, it is not required to issue a so-called notice. But he was kept on reminding to complete his work, and he neither applied for the extension.
Sir, you are cancelling that on the contract. You are saying that he need not be given notice.
Yes, sir, as per the Railway Board circular. I'll bring it.
Do not accept circular.
Your Lordship, give me an opportunity. I'll bring on record the reminders sent to him.
Not reminder. Where is the notice?
I'll bring that Railway Board notification. No, it's not there.
Then we will allow the petition. Yes, take it.
This is not appearing for last 2 days.
All right.
Your Lordship,
the petitioner has prayed for the following relief.
Your Lordships, even his last bill, he didn't came for the measurement, you also.
Impugned action.
And there's a clause for arbitration, Your Lordships. There's a clause for arbitration.
Bracket Annexure 5. Petitioner, the contract has been terminated.
And his claim is after 3 years. His money claim is after 3 years.
Without notice. The blood counsel for the respondent submitted that.
Lordship, I follow my counterfeit with Your Lordships.
There is a question of order that even normal course, if the contract is
Date of completion was in November 2014 and this terminated in March 2015.
you need not invoke a termination,
No, Your Lordship,
but he should be given notice. No?
by humble submission, Your Lordships.
But work was not completed.
The work was not completed.
Don't disturb by giving dictation.
Your Lordship, some submissions.
You will have an opportunity after dictation.
Okay.
Can know.
Able.
What is that?
The counsel for the respondent submitted that
That notice need not be given to the petitioner in the light of Railway Board circular. It is also submitted that year of the contract was completed on 7/11/2014. However, work was not completed by him. Therefore, impugned action has been taken. Impugned action is in respect of termination of contract. No doubt, 10-year contract was up to 7/11/2014. However, the work was not executed complete by the petitioner. Therefore, the concerned respondent has not taken any decision either to extend the contract tenure, and in the absence of same, proceeded to terminate the contract on 11/3/2015. Because of the contention that concerned respondent need not issue notice before termination of contract, read with the Railway Board, is not tenable in the light of the tenor tenor of Article 14 of the Constitution. Further, it is contended by the Land Council for the respondent that petitioner has alternative remedy of arbitration. So it is to be noted that it is a case of a violation of principle of natural justice, in such circumstances, Article 226 could be invoked. Accordingly, petitioner has made out a case set aside, reserving liberty to the petitioner respondent to initiate action in accordance with law after giving ample opportunity of hearing the light of appeals court decision in the case of Kranti Associates versus so and so. The extent that in the event of termination order is amenable to judicial review, in such circumstances, all necessary formalities were required to be undertaken by the concerned respondent who has taken impugn action. Yes, you want to say something?
Yes, Your Lordship, I'm obliged for Lordship noting down my submission, Your Lordship, but there are certain things which I like to submit it further. Firstly, the DOC, that the date of completion was sometime in November 2014, Your Lordship had noted down. Thereafter, repeatedly we've been asking him to complete the work. He had just completed. All I'm submitting from my counterfeit that only 15% of the work was completed. Third running account bill was paid. Fourth account bill, he was supposed to come for the measurement. He refused to come for the measurement, and that bill is also pending of 18,000 rupees. He can avail it. And neither after the completion he had applied for the extension of the work, nor the security deposits were renewed. So the respondents railway had no other way out but to terminate the contract, and in my humble submission, after repeated reminders to them, that either you apply for the extension.
The same thing here.
Apply. I'll not repeat. I will not repeat.
Yes, sir. Yes, at this juncture, when counsel for the respondent submitted that before impugned action dated 11/3/2015, the petitioner was made known through notice for settling certain bills. It also submitted that the petitioner is stated to have executed only 15% of the work, and running bills have been bill read with payments have been made, and some of the bills were required to be settled. These issues are not necessary to examine whether the impugned action is in order or not. These are all the factual aspects of the matter which were required to be agitated before in the arbitration. These material information will not change our decision. Accordingly, it is rejected.
Obliged.